各位委員，
Members, good morning. May I call to order the meeting of the Trust Law Amendment Bill 2013. We're going to meet one deputation and one individual today. They will make oral submissions on provisions of the bill. So let's get started, and let's confirm the minutes of our last meeting first. Right. Before we have not received any proposal for amendments. Members, can we confirm the minutes of our last meeting? Thank you. All right, the minutes are confirmed. We're now going to meet with the administration and deputations. Let us welcome the administration into the room. Please invite the representatives into the room, and please invite the deputations to join us as well. All right. Good morning, officials and also deputations.
version.
We have a deputation and also an individual present. And I'd like to remind members that their their remarks will not be protected by the Electoral Powers and Privileges Ordinance. And each deputation or individual will have 5 minutes to speak. We've already received written submissions from these deputations, so they don't have to repeat what's already in the written submissions. And as stated in the invitation letter, they invited to focus the remarks on the following 4 areas. First, their views on the administration's responses, and also their view on abolition of the anti-perpetuation rule, perpetuity rule, and so also their views on trustees' exemption clause, and also their views on anti-Bartlett versus Barclays provisions. All right, I will first invite Mr. William Ahern to speak.
The Joint Committee on Tax Law Reform wholeheartedly supports the amendment bill. It is vital to Hong Kong regaining its rightful place as Asia's leading trust administration centre. The amendments are long overdue. They have been very carefully prepared. They have been subject to a lengthy and detailed consultation process by all of the stakeholders over the last 7 or so years. Although we as a committee would have liked the bill to have gone further in certain areas, and we have made detailed submissions in that respect, we do not wish to jeopardise the passage of the bill in its current form in this session. Mr. Lee and I would be happy to try and answer any questions that the members may have on the bill, but with respect to the rule against perpetuities and the rule against excessive accumulations of income, we would just like to point out the following. The rule against perpetuities abolition does not mean that all trusts will be perpetual. It just means that they can be perpetual. Settlors can choose a shorter period if they like. The rule currently is overly complex. It's out of date and unnecessary because its origins are in response to a distinctly Anglican problem which does not apply in this place. Our competitors are doing away with it and we need to do it as well. It is entirely unsuitable for many commercial trusts such as investment funds and pension funds. If you'd like to speak about Barton Barclay, Mr. Lee would be happy to address that issue.
Mr. Chairman, members, thank you very much indeed. The provision concerning Barclay and Barclays Bank is a provision that enables those who have companies to be able to allow the directors of those companies to go on running them despite the fact that the shares are held by trustees. This is a very important position for many people who hold companies, and that sort of clause is frequently used in the UK to permit that sort of position to happen where there is a trust. I think it's extremely important for ongoing provisions for trusts and for the industry that that sort of provision is included. Thank you.
Okay, thank you. The two speakers from the Joint Committee on Trust Law Reform. Next, we have Mr. David Gunson.
Yes, good morning, Chairman and Committee. Thanks for the opportunity. I'm a pension administrator, and 20 years ago, Bill Ahern and David White, who's a colleague of Mark Lee's, sat and came up with recommendations on reform of trust law. That's 20 years. The paper that was written, I wrote, but any one of us could have written it, and it contained many recommendations which are before the Bills Committee today. In other words, I think we have an opportunity at last to reform trust law, and I can only urge the Bills Committee to push this. As a pension administrator, I am constantly running up against difficulties in trust law in Hong Kong, and I wholeheartedly support the abolition of the rule against perpetuities. When it comes to trying to reorganize pension funds, particularly old pension funds, this can be quite problematic. The rule is something purely to do with the acceleration of vesting of interests in land, and this really has absolutely nothing to do with Hong Kong. I would also say that on the question of a statutory control or level of behaviour of trustees, in principle I support the idea of there being some general standard of behaviour, but you've got to be very, very careful when you're defining bad behaviour, especially in trust law, and it's probably better left to the courts. The courts are the regulator in this area, and so if the Bills Committee is going to go off down the path of even considering some sort of statutory standard of trustees' behaviour, I would recommend only that it be kept conceptual and no more than that. One of the things I think that is not properly understood, and it's clear from the draftsman's words in this bill, is what exactly is the trustee's standard of behaviour. You see, you've got four standards. If you can call it that, you've got the criminal standard of dishonesty. Then you've got the law on negligence. there. Then you've got the reasonable man. And right up the top, you've got prudence. That's the trustee's standard. And yet we've got in the bill this concept of reasonableness, or a trustee acting on behalf of people. A trustee never does that. And so I think that what the Bills Committee needs to do, if I may say so, is to have a careful look at synchronizing these concepts in the bill, because at the moment the bill has introduced differing standards. One last remark is to do with the Barclays Bank case, which has been sculling around for years. From a certain point of view, one has to ask why it is that trustees, as a special class of shareholder, holding shares in a special class of company, say a private company, should be treated in some manner or other that's different to all other shareholders. Well, I can certainly see that trustees do have difficulties because as a pension administrator, this is something that we have to deal with all the time. I do think that certainly in the area of pension funds, the liabilities that accrue to pension fund trustees can be quite severe. So when 10 wheels come off things, as they do in the stock market, it's always the pension administrators that are to blame, do you see? And so from that point of view, if you're going to operate a trust owning shares in a private business or listed shares, then I think that some consideration needs to be given to limitation of that liability, because at the moment it's open-ended. I think that's all. I could go on. Be pleased to answer any questions if the Bills Committee has any for me.
好，多謝以上。
I'd like to thank the two deputations and Mr. Gunson for their views. If you brought along the text of your speech, please leave it with our secretariat for our reference. Well, we will now ask the administration to respond to the comments made by our deputations. Who would like to start? Thank you, Chairman. I also like to welcome the deputations and members of the public attending our meeting today. We have a focused discussion today, but before we do that, I have noted their submissions on the various issues, which we've also expressed our views on those issues at earlier meetings. I'd like to welcome the three gentlemen who are all supportive of the bill. For example, I hope that the Bills Committee will also support this bill. Regarding the new perpetuities and accumulation ordinance and our proposed amendment in that regard, the views of the three gentlemen are consistent with our proposal. In fact, we have heard the views of the industry before we put forward this proposal. So I therefore will leave it to the committee to see whether members have any further views. I understand that last time members suggested that for a relatively long period, 150 years would be preferable, or would we accept that there would be no time limit? We have tried to persuade members that there's no issue relating to land, and therefore we can consider, not setting any time limit, so that we can, make Hong Kong a more attractive common law jurisdiction, including the UK and Singapore. I think Hong Kong will become a more attractive jurisdiction. The other issue is the Barclays versus Barclays case. We've heard this view, and I'd like to reiterate that this is actually from the perspective of the trustee, but we must bear in mind that under the common law system at the moment, it's different from the consideration of not setting any time limit. In other in the systems of other jurisdictions, we've not seen the amendments as proposed by the three gentlemen. And this is not the same as the issue of perpetuities, because the land issue consideration is absent in Hong Kong. So we need to look at this carefully. In principle, we have reservations as to whether or not we will not accept it totally. I wouldn't say that. But when we go to the question of the control of underlying companies, and if anything should go wrong, who should be held liable? Under the common law, there is a way to deal with that. If we want to change that, we need to have a detailed discussion as to what change we want to make, and how in the principal ordinance can we, do it so that we can cover the different types of trust deeds, which, so that it could be implemented in a reasonable manner. Of course, we cannot trace back to the intention of the settler. I mean, in theory, anybody could be a settler, but then that person may not want to express his views. So I think for the administration and electrical members, we need to adopt a forward-looking perspective. That is, from the perspective of the settler and that of the beneficiary. If we were to make this change or amendment, would it result in a major change in their powers? And the consequences that may arise may be beyond our control. So we therefore think that this is something which we need to look at more carefully outside the scope of this bill. We agree that we'll continue to listen to the views of the industry. After we've completed the scrutiny of this bill, that's not the end of the story. We will not, as in the past, have to wait for many years before we will review this again. In modern day society, when the financial industry plays such an important part in our economy. Now, we will, not too long after the enactment of this bill, we will look for the opportunity to amend or further improve on the provisions. Thank you very much for that response. I believe members have heard the views from both sides, and later on we will be having a very detailed discussion. We have received written submissions earlier, and I don't see that there are any new points raised today. So I think we can make reference of the submissions that have come in, and also the comments made just now as the basis of the discussion. Yes, Mr. To, would you like to put questions to the deputation? Well, normally we would let the administration respond. And if the deputations or individuals would like to leave, they may do so. But if you members have questions, I don't mind staying a bit longer. Mr. To. Thank you. I'm concerned about the question of perpetual trust, especially in relation to land. At the last two meetings, I pointed out that in Hong Kong is a very small place. we have limited resources and limited land. I'm worried when I look at the trend. I mean, projecting several decades or centuries ago, I don't know. But for example, there are mainland people who come to buy some properties. It's very odd that they don't live in those properties. There are various reasons why they don't live in these properties. For example, some of the luxury apartments in West Kowloon, they would buy, leave it empty. They have safe there, antiques and paintings are stored in those units, and they use it as a vault, and they don't lease it out. And in future, if they were to set up a perpetual trust, and they will hold on to it perpetually, and when you have more and more people from outside, not necessarily all from the mainland, they could come from anywhere. The trend now is that these people, I mean, the interesting about them is they don't lease the properties to other people, and they do not live in them either. So, in that case, after a period of time, I mean, our land, there would be severe shortage in terms of our land resources. The government can of course impose a tax for premises which are not occupied, but unless you go to a very extreme scenario or charge 50% tax annually, otherwise, I think other forms of wealth are not so problematic. When it comes to land, you're talking about locking up some of the land which are not released to the market, and is actually, used by some people as safes or for personal reasons, like treating them like collector's items. And money is no problem for these people. So how do we deal with that? Even in places like the UK, they have owners of castles, and the families, if they cannot afford to keep them any further, but very often in the end, because the upkeep is getting more and more expensive, the owners cannot cope. But looking forward, I don't think we are able to control a similar situation. So given the present restraint, could we at least extend it a little bit so that there will be an end to it? We can't predict the future, but if we now lay down the rule, and in future we're going to face a severe problem in terms of land supply, and then you want to revert your policy, it's not fair to some people. So I don't think we should go to such an extreme, and I think we should set a timetable, although we're extending a little bit. Thank you, Mr. To. I'd like to ask whether the deputations have considered this problem. Any response from our deputations?
The answer to that probably is, first of all, the number of mainland Chinese who presently use trust is pretty small. What may happen in the future, of course, I cannot tell, and it will be difficult for you, sir, too, as well. I wonder if this solution is best not dealt with, not in trust law, but in terms of requiring property not to remain vacant for a period of time. And therefore I would suggest that the solution doesn't lie with this bill and with the question of perpetuities, but with other legislation for that purpose.
Thank you, Mr. Lee.
Really, just to reiterate what Mr. Lee was saying, I commented on, actually, Mr. To, on this point in a...
Sorry, sorry. 因為冇聲喺度。
Carry on. Yeah.
No, just to reiterate what Mr. Lee was saying, I think it's a different legal point that you're raising, and I actually commented on this indirectly in a note that I'd sent by email 10 days or so ago. The point about perpetuities is that it's a rule designed to encourage the vesting of interests in land so they don't remain unvested. By vested, I mean owned. And actually in Hong Kong we've already got that. You see, nobody owns the land except for the government. And so You know, you've got reversion automatically under any lease. I mean, I and my wife own a flat. We call it our home. We call it, you know, we own it. Well, actually, all we've got is the use of it. Do you see? So from that point of view, I don't think that you've got a difficulty under trust law if perpetuities are abolished. And as Mark Lee was saying, I think it's better dealt with under some other legislation, land law, and we're pretty close to it anyway.
好，多謝你哋。
Thank you. Yes. The question is that regarding the last response. I thought about this also, but if China implement one country, two system scenario, and there won't be any changes in 50 years. But after 50 years, they can take back everything. But if we were to implement this, and if in future there is a reversion of all the land titles, the government will take back all the land, I think that is simply impossible. So you say in your first answer that there are not many managers, using trust. But in future, if they realize that this could be made perpetual, and I mean many Chinese, and also same for other people from other countries, if they have families which can have assets which will not be passed on to their descendants, it's not vested, and it's simply made perpetual. Now, when it comes to land, given that Hong Kong is such a small territory with limited land supply, then I'm really worried. I think that there are unique circumstances which warrant unique treatment. We're not just talking about the abstract concept of trust, but rather when it applies to certain territory, will there be any impact? That impact may not happen in the next 30, 40 years, but in future, such behavior may have serious implications. You're talking about, the social resources implication. Mr. Liu.
The first questions are for Mr. You say that the competitors are doing away with the rules against perpetuity and the rule against accumulation. What competitors would that be? I take that to mean that the competitors have abolished the RAA and the RAP. Now, could you tell me what competitors would that be? And the second question is, now, what do you say about having a finite period of perpetuity, like the UK? That would do away with a lot of the uncertainties and the complexities you mentioned about the computation of time. Now, do you see that as a possible option for Hong Kong?
Mr. Ahern.
I wasn't sure whether you're addressing the question to me, sir. Firstly, in a comparative sense, we have written a table which we submitted to the government comparing various aspects of trust law in 18 jurisdictions, and I believe that table is before this committee. Perhaps. Yes, but it's quite difficult. But my colleague Mr. Lee put it together, so I might ask him to tell you which of the other jurisdictions where it is common to administer trusts this rule has been done away with, so that he can answer your question in detail. In terms of the other solution, which I think you're suggesting, is to lengthen the statutory period that trusts may exist. That has happened in some places. I know that in the British Virgin Islands they recently changed their law to extend the maximum period that a trust could vest to 360 years. So that is one possible solution, but I don't think it goes to the root of the problem. And the root of the problem is that the rule itself was a response to conditions which honestly do not exist here. So I think making the period longer whilst it might be better, doesn't cure the essential fault of the rule and its applicability in modern times and in Hong Kong. Perhaps I'll ask Mr. Lee now to give you a more comparative analysis of the jurisdictions.
In the interest of time, maybe I'll take a look at that later. But I have a follow-up question. You said that, you see, it has, basically you're saying that the rule against perpetuities is anachronistic, right? And of course I heard Mr. Gunson said the rule is about vesting of interest in land. But we all know that trust property, the form of trust property, has taken a much wider spread. It covers a lot of shows in action nowadays. Now, of course, I can see that the rule against perpetuities can be a bit of a nuisance for trusts and pensions that operate in the financial market. But at the same time, as legislators, we have to take into consideration of trusts of a more private nature. But do you see that there should be a distinction between a private trust and trust of a more public nature, like those which nowadays operate in the financial markets, and that should have the rule against perpetuities confined to the operation of the purely private trusts? What do you say? What do you say to that?
I say that the objections to the rule apply both to trusts for families and those for a much wider class of beneficiaries. I also think it would be very difficult to somehow define in this context what a private trust was and what a public trust was. I think the other thing we need to remember in the private trust context is that when we talk about perpetual trusts, it's not as if the beneficiaries don't have a say in these things. Even trusts where the beneficiaries have interests at the discretion of the trustee, if they all get together, they can bring the trust to an end. So there is a mechanism within the existing law to stop trusts carrying on for an endless period of time if the beneficiaries so wish. I do see the point of your distinction, but I think it is not one that would be a sensible or easy way to express in the law.
Chairman, just one final question.
Mr. Lee, have some...
Sorry.
Sir, if I just may add, when you're kind enough to look at the comparison chart,
Yes.
could I just mention that not shown on the comparison chart is what the United States has done,
Yes.
and state by state, a large number of states have now abolished the rule against perpetuities.
Right.
They've looked at exactly what you've been saying and come to that conclusion.
Yes. Thank you. Now, could I just cite one statement from the Law Reform Commission of the UK that I believe underpinned the philosophy of having a fixed period of 125 years in the UK legislation. May I just quote that to you and ask you to respond to that statement? It said, I quote, sorry, it's in my cell phone here, a significant and very distinguished minority of those who responded favored the abolition of the rule against perpetuities. A majority were against this option, however. They considered that the rule still fulfilled the function of controlling the power of one generation to dictate the devolution of property, that such a function remained an important one, and that no other rule of law was either sufficient to or as effective in achieving it. Some respondents consider that the abolition of the rule could have adverse economic consequences. There was a widespread view that if the rule were abolished, said laws would undoubtedly create future interest which they could not under the present law. So, what do you say to that?
First, I think I'm not sure that I know this is a very difficult problem, but I'm not sure that a comparison with the UK is necessarily the total comparison for Hong Kong. That's point one. Point two, we've come at this...
Sorry, why not?
Because I believe that most trusts and most other things in terms of structuring that are carried out, both for commercial and for other purposes, are better compared with Hong Kong with, say, Cayman or Jersey or Guernsey than it is necessarily with UK. Second, the trend certainly has been to go towards perpetual trusts in those jurisdictions, and as we've said, it is to a very large extent a voluntary process, and we're looking at assets that have changed vastly from just the landed estates that the UK dealt with at that time. And my colleague has mentioned the question of beneficiaries being able to stop trusts if they choose to at any particular given stage if they're all of full age and capacity to do so.
Yes, but you say Hong Kong should follow the example of Cayman Islands and British Virgin Islands.
Well, I'm saying that this is the trend, and this is what would be necessary in my view, just my view, but I think held by a lot of other people here, to make Hong Kong competitive in that area and to attract trusts not only for private purposes, but certainly for commercial purposes. And the whole of our thrust has been to try and make Hong Kong the base for this industry worldwide, and to look to the ability to benefit Hong Kong from the changes that are proposed. And I believe this to be one of the important factors for that purpose.
Well, I'm slightly worried that you say that we should compete with Cayman Islands and British Virgin Islands. Those regimes may not be, I don't think, in the environment of the future, maybe 2 decades. It may take a very, very different. Things will take very differently with the new philosophy now setting in about regulations and all that stuff, global regulations.
I think you're definitely right about that, but the consequence of abolishing a rule of perpetuities has no tax consequences whatever. So I don't think that if we do things that other places do that have zero tax consequences, I don't think we can be rightly compared to those places for that reason. This is purely a trust law issue, nothing to do with tax.
Next, Mr. Chen Kim-po. Thank you. I know this is the relevant law has not been changed for many years. Since the deputations are here, I take this opportunity to ask them if the amendments are passed, how much can we benefit in terms of competitiveness? How do we compare with Singapore? What benefits will that bring to us? Which one from the guests? Mr. Lee?
Sir, I advised Singapore in 2002. It passed its law in 2004. As the bill now proposed, and we're very supportive of this bill, we would be slightly ahead of Singapore in what Singapore did in terms of changes in 2004. The other more major jurisdiction in Asia was Malaysia, which changed its law in 2010, having started in 2008, and it took a much wider view of the changes that might be made in a number of areas. And here I simply say that we're very supportive of this bill, and we don't in any way wish to jeopardize its progress, and that we wish to see it as law. There are a number of areas, such as the Bartlett position and various other things, which I believe would be very helpful to make us very competitive. And I can say that in Singapore, the professionals are in some respects, and this is in a paper that we've written, concerned that because they do not have the methods to use, therefore they are losing business.
A follow-up. Of course, we're not very happy that the law has only been amended after so many years. What do you think? Should we review it in every 2 years, 4 years, or 5 years? How often should we update the law? Because our other jurisdictions are improving the law every now and then. So what should be the time frame for our constant review to ensure competitiveness?
So we would like to see the law reviewed quite shortly after this amendment bill is made, particularly to look at this Bartlett and Barclay question, and also to reconsider the concept of providing for non-charitable purpose trusts, and you would have seen our submissions in that respect. From a general perspective, I honestly think you don't want the law of trust to be reviewed every 2 years. It's too disruptive to the law. So I would have thought an early review on those specific areas after, say, 2 years would be excellent, but I would have thought every 5 or so years thereafter would be more than enough, is my opinion.
Mr. Consul.
To add a couple of remarks, as I mentioned, I'm in the pension business, and I can tell you that the law as it stands at the moment is preventing us from carrying out pension fund work here in Hong Kong. I'll give you 2 examples. I arranged the transfer of pension money internationally, scheme to scheme, and Hong Kong, I'm happy to say, is recognized internationally as a pension scheme jurisdiction. However, if I want to reorganize, say, a US or UK pension fund right here in Hong Kong, and I've got one huge example at the moment, I can't, because I've got a law on perpetuities blocking my way, and I've also got problems to do with liabilities of trustees. If this bill goes through in its present form, I can guarantee that I get that work, and it's huge and it's expanding. The other example is to do with using Hong Kong as a pension administration centre for Asia. There's no reason that Hong Kong shouldn't become the premier jurisdiction for pension administration right throughout Asia. It's commonplace for multinational businesses to have Hong Kong as its headquarters. It would be quite logical and efficient for Hong Kong also to be the pension administration centre. It's great for tax as well. It allows people to move around Asia in their jobs without disruption. So for these reasons, I think you'll find that it is inevitable when this bill goes through that we're going to get a lot of business in Hong Kong.
Mr. Chairman, if I may add one point. Generally speaking, this will give us, when I say us, the trust, private trust industry in particular in Hong Kong, the opportunity, once we have this as law, to go to all of those lawyers and settlors around the world and say, come back to Hong Kong. And this is what we've been waiting for many years, and we've got a good story to tell them as to why they should come back if we get this bill in its present form.
Chairman, my final question is this. The administration has already responded to the submissions made by different persons and parties, including the Joint Committee. I'd like to know whether or not you still have further comments on the responses from the administration.
It would be that the administration has very kindly listened to all our submissions. We've talked very closely with them. We obviously have thanked them very much for the work they've done, and they've done very good work. And we have a bill that we are wholly supportive of. I am concerned, and I think that a number of members of the Joint Committee are concerned, and the industry is concerned, that it would be very good if we could go somewhat further in the sort of ways that we have mentioned, because our whole emphasis is really the benefit of Hong Kong and the jobs that will be created in Hong Kong and the addition to the economy of Hong Kong by what we're trying to do. And if, as the administration has been kind enough to say, they are good enough to look further at some of these points, then we shall be that much more competitive and we will get that much more business, not just of a private nature, but very commercial nature. Funds, pension funds, unit trusts, everything will come in that sort of way. I believe that we are the premier centre in Asia. I really do, in terms, I don't speak for me, but I speak for my colleagues, because you have the staff and the people and the training and the go in Hong Kong, which frankly Singapore does not have. And I think it's time that we really took advantage of that.
Okay, thank you.
Okay. Ken.
Thank you very much, Ken.
Thank you, Chairman. The gentleman's argument, both on technical grounds and on business grounds about the reform of the trust law is they're well heard. But as a legislator, as my honourable colleague Martin has mentioned, we have to consider the legislation on a wider perspective. Yes, I mean, on technical grounds and on the business case, yes, I mean, all these proposals are welcomed, especially from the settlers or the trust business perspective. Now, Hong Kong is never similar to the UK in terms of its landlord. We never have any freehold land, and that is a fact in the past, and that is also a fact currently. By abolishing the rules against perpetuities, now it's just a prediction. Of course, we don't have the crystal ball. We cannot see how the economy will be going in what direction in even 5 years' time. Now, by abolishing the rules against perpetuities, there could be a fear that the perception of the settlers and other people would have in Hong Kong is that, oh, Hong Kong, yes, we can have a trust that could go on and on forever. And by doing so, because we already have very scarce supply of land, be it just a leasehold, how would you predict our land price will go if we actually do abolish the rules against perpetuities? Bearing in mind, of course, you gentlemen have a kind of business model that, yes, if this piece of trust law is passed in the current state, then you have more trust business coming to Hong Kong. But would you have a kind of prediction about how our land price would go if we have more trust business? That's my first question. If one of you gentlemen could answer my question first.
I would be very surprised, Mr. Chairman, sir, that the abolition of the rule against perpetuities would have any impact whatever on the land price. I don't know what proportion of land now in Hong Kong is held through trusts, but I imagine that it's very, very small. A lot of the land is held by publicly traded companies, so the interest in land through shares in those companies is a circulating asset. I do not think that the abolition of the rule would create a rush to buy Hong Kong real estate or to put it into perpetual trusts. I think it would have minimal or perhaps no impact on that price.
Can I?
Yes, sure.
So, if I may add, I quite agree with my colleague. I don't think it would have any impact at all. I also think that the measures that you have created in terms of stamp duty have had a very considerable impact on people wishing to put Hong Kong property into trusts and other such arrangements. And equally, of course, there's no estate duty in Hong Kong. So there's no incentive for people to do that sort of thing. If it comes to creating trusts, then, of course, it's a voluntary exercise in terms of how long they have their trusts, and they can be advised appropriately. And frankly, if I just speak for me, I should think that very little Hong Kong property is put into trust structures that I have created over the last 20-something years. Certainly there is land, but that land is not in Hong Kong. Mm-hmm. And equally, a large amount of the business that I've done, not tax-driven under any shape or form, but mainly driven because people wish to see to future control, see to future succession, to avoid probate, has been carried out using Hong Kong as a hub for suitable people from elsewhere. Mm-hmm. It's not to do with Hong Kong land.
And if I may add one point to address your point, sir, with respect to perpetual trusts. Speaking personally, I would be very, very careful as an advisor advising a settlor to establish a perpetual trust. I think there are places for them, but I think you'd be very, very cautious to allow that possibility, but I think it should be offered under the law.
Okay. Mr. Constant.
Just very briefly, on the point of property prices, I'd like to support what Mark Lee has said. We've actually got 9 taxes associated with land in Hong Kong when you add them all up. And it's quite striking from the pension administration point of view to have an entire possible asset class removed because of the stamp duty that's been imposed. And when I was discussing this with, I can't remember who, somebody from the financial services branch a couple of years ago about the impact of stamp duty, I said that although the government had said that this would hopefully lead to stable property prices, I said no, it won't, it'll increase them because it's limiting the supply. It's got nothing to do with perpetuities at all. And I just reiterate, it would be completely neutral. The importance of this rule, I think, can't be overstated, and the difficulty that we've got is that it applies not just to land, it applies to anything that is owned by a legal entity that is assembled in the form of a trust. And I, for myself, cannot think why one particular form of legal arrangement should somehow or other be singled out for a time limit to be placed on it. I mean, why should it? Limited companies can last forever, in theory. So can societies. So from that point of view, I think what we're talking about is something that is really very different. I would have no fear myself about property prices or the availability of property from the perspective of a pension administrator at all if this rule were abolished. I think it absolutely no effect at all. I do see that the rule is not, if it is abolished, it's not compulsory for trusts to be perpetual. It's possible for them to be. And beyond that, I think your worries about property prices and the availability of property are largely driven by stamp duty, nothing else. Thank you.
Well,
Mr. Chairman, I have 2 more follow-up questions. One, if you are asked if you want to add one more feature to the current proposed bill, what is on top of your wish list? Is there anything else which is quite important which this current bill has missed out? If you want one additional feature to this bill, what will it be?
We wanted one. I think we agreed that it would be the Antley, Bartlett Barclay clause, which allows people to put their private companies into trusts and maintain the management and supervision of them without interference or undue interference from the trustees. That is the thing that I think would really set us apart. And I believe the administration are interested in this idea, and if they would be happy to speak to us over the next year or two to look very seriously at that provision, we'd be very pleased to work with them on that.
okay.
Chairman, can I ask the administration to answer this question? Why can't they put it into the current bill? Because if they're going to do it in future, it will take another 3 or 4 years.
政府需唔需要做一個簡短嘅回應？
首先現在呢
First of all, under the trust system at the moment, the settlor can, through different means, and he can exempt the liability of the trustee. If the trustee owns many companies, and under those companies there are subsidiary companies, there are many ways through which the trustee can participate in the management of these companies, or he may not participate. So we have to look at 3 parties: settlor, trustee, and the beneficiaries. From what we've heard this morning, from the trustee's perspective, that is, under the circumstances, there might be a scenario where I might not participate in the management so that I wouldn't be reliable. So when a trust is set up, the settler and the trustee should have agreed on the respective liabilities and extent of their participation or involvement. So at the moment, there are possibilities through which, through negotiation, this issue is dealt with when the trust is being set up. The industry is putting forward this proposal because the law states clearly that almost under any circumstances such liabilities could be exempted, if my understanding is correct. Well, in that case, well, this is an across-the-board approach. A third party may have the impression that you're, giving protection to the trustee. But of course, when in the course of negotiation, when fees are discussed, this would be considered. So we've heard the view of the trustee, but we also need to understand why the trustee finds that there is a problem. If the trustee can, or if the settler believe that they can agree, on the terms to be put into the contract, and no matter how the instrument is what the instrument said, he will be exempted. The trustee will be exempted. I think we have to look at the perspective of the settler and the trustee and ask whether there's any problem. So I think we need to, have a better understanding. Eventually, when we're going to draft that provision, we need to be very clear. There are no reference from any other common law jurisdictions on this point.
I understand from Mr. Gunson's submission, there is a paragraph containing the list of permissible investment to be invested by a trustee, and Mr. Gunson recommends a kind of prudent man approach. Is that correct, Mr. Gunson, rather than giving a list of permissible investment in the trustee?
It's something that I've been banging on about for about 20 years. If you're looking at benchmarks, I'm sorry, Chairman, I won't take a lot of time. It's my favourite subject. If you're looking at benchmarks internationally on trust law, the prudent man rule is clearly the international benchmark. The difficulty with a legal list of permitted investments is that it is inherently not prudent just to rely on that list. Just because you invest on the list doesn't make it prudent to do so. That's the difficulty with having a legal list. It's all very well to say, well, it makes it easy for Auntie Chan and Uncle Albert and Mongkok, and they're administering the deceased estate, but I'm afraid it doesn't work out like that. And the real test of any rule on trustee investment is whether or not beneficiaries are better off. And it's very clear from the studies that have been conducted over many years internationally that prudent man rule is by far the best. And I would believe that that's the direction in which Hong Kong should go. If it doesn't do that, it's going to become an aberration as the default position. We can write rules all day long as to how we want to invest, but prudent man rule is the default position, and certainly that's the case for pension funds.
Thank you, Mr. Gunson. Chairman, can I ask the administration to answer this particular point? Because I understand that under the current proposal, there are certain classes, of course in the old trust laws, where there are certain classes of investment which are prohibited. And beyond that, it will be up to the agreement between the settlor, between the trustee and the settlor, into which, categories of investment the trustee can make. So is the prudent man approach relevant here, or have you not tried to, incorporate those, principles? Thank you.
主席，如果係講緊係
Regarding the classes of investment that can be made in a trust, I'd like to reiterate that if in the instrument there is no specification, that means it is a default position to attract experienced investors or settlers. Now, or in commercial operations, we see that in many cases the schedule is not used. They have already, no, this is not about statutory care, but rather there is already provided in the schedule what classes of investment can be made. We propose that the schedule be kept. And after the last tsunami, financial tsunami, we saw a particular case. And I said there are many family type of private trusts. And these settlers are not really professional settlers. They might not seek the service of professional trustees, but just friends they know. So the schedule will be able to help such people. Thank you. Chairman, beg your pardon. Mr. James still put a question to the deputations, and Mr. Ahern had a reply. And though Mr. James Toh is not here, I'd like to supplement or clarify. Mr. Toh talked about the situation of perpetual trust. Well, in Hong Kong land, it's not a problem. But Mr. Toh was referring to properties built on land. Now, if it is owned by certain persons, and it might be held in perpetuity, and it will not be used for occupation. Mr. Ahern said that it should be separated from land, because after the lease expires, although Mr. Toh said that it's not possible for the government to recover all the land, but the lease may be extended on certain conditions, and we can consider using land use or the rent as a condition for extension. And Mr. Ahern was not referring to apartments. He was saying that in general, for even in a perpetual trust, the trustee and beneficiaries may agree to end a trust. Mr. Ahern, now, Mr. James Toh was referring to a case where a person has purchased a unit, and then a perpetual trust has been set up to hold the apartment. Theoretically, the person is going to use that particular apartment for a certain purpose forever. I'd like to ask Mr. Ahern whether in any way can the lease, the trust be ended. So I'd like to ask Mr. Ahern whether his remarks were only applicable in general. Can that be applied in Mr. James Toh's case?
Mr. Chairman, I think you're speaking about the rule in Saunders and Vautier?
Perhaps,
Yes.
主席或者我好簡。
Chairman, perhaps I should use English.
You've mentioned that even in trust under without a limited period, there are some standards under which the trustee with the beneficiaries may put it to an end.
Trustee, it's just the beneficiaries on their own. So if the beneficiaries are all of age and capacity get together, they can bring any trust to an end at any time, regardless of how long the trust instrument says the trust may go on for, or even if it is perpetual. So it's not as if the beneficiaries are powerless to end these trusts if they want to. And I think that's a very important
主
point.
席，咁就係話關於頭議員講就係 if we are focusing on a trust under which the said law just put his property into perpetuity, And does that still apply? Does what you said, and under what circumstances, is that a specific beneficiary under that trust?
No, it's an old case called Saunders and Vautier, but the idea is that if all the beneficiaries who we know, all the ascertainable beneficiaries who are of legal age, so they're all adults and they're all have capacity, they can get together and say to the trustee, we don't want this trust anymore, transfer the property to us directly, and the trustee must adhere with that direction.
係你想跟住呢條要話
You'd like to follow up on this?
Only. Yeah. Because I think this is not, well, the general position is yes. I mean, if the beneficiaries of full age and legal capacity get together, they can end the trust and ask the trustee to transfer property to unanimous agreement by the beneficiaries. But there are quite a lot of exceptions to this rule. For example, I can think of is, for example, if the beneficiary is only entitled to the income of a property and not periodically, I don't think that it is quite difficult for them to get together or to form a view. Or, for example, there may be cases under which the beneficiary is just a group of people. You cannot even identify who are they, then it will be quite difficult. So I think we need to get the legal position right, whether this is, a determination of a trust by the unanimous agreement of the beneficiary is the general case or not. I think perhaps, Chairman, could I ask our legal advisors to give us some written opinion on that? Thank you.
Legal advisor, can that be done? Yes, that can be done afterwards. Mr. Sheck, do you have a question? Yes, thank you, Chairman. I hope Mr. David Ganson can explain this to us.
On your submission, paper 1089, on your D aspect, on the prudent man approach, prudent man law, how do you relate that to E of your same submissions? Does this give a sense of conflicts in there? Can you just elaborate between D and E of your submission paper 1089, your submission to the chairman of Bills Committee? On your point D and related to point E, you have that paper, which is an interesting concept,
You're referring to, in E, the idea of regulating trustees, is that?
Yes, on the prudent man
They're
rule.
two separate things, Mr. Sheck.
Yeah, I want to know how that's separate and then somehow it's related into the whole concept,
Well,
If you can elaborate a little bit more, I'll give you the time to do it,
as I mentioned before, I'm not sure if you were here, the
I was
question
listening.
of prudent man rule is purely to do with trustee investment law itself. In other words, the scope of a trustee's investing powers, because a trustee can only do what it's empowered to do. And so that's there, purely to do with trustee investment law. What I'm referring to in E is a general comment that it comes around from time to time, not only in Hong Kong but in other jurisdictions, on whether or not trustees themselves should be regulated. This has nothing to do with trustee investment law, but the regulation of trustees. Now, in certain areas, there is regulation of trustees. For example, in the pension arena, there is regulation of who can be a trustee and the standards that they have to meet. There's no conflict between these 2 points, one being to do with trustee investment law generally, and the other one a question conceptually of should we be regulating all trustees. And my view, for what it's worth, and I think it's a very commonly held view, is that the regulation of all trustees as such is not such a good thing to do. I mean, we've got regulators already. They're called the courts, and they've been very successful over the years at regulating trustees. So I hope that's explained what I had in mind, Mr. Sheck, in those 2 paragraphs.
But can you elaborate on the E paragraph to the extent that you're talking about your papers of 30 years, and which is quite interesting to the extent that concept. I'd just like you to elaborate on that aspect of how this would affect the present legislation.
You mean regulation of trustees?
Yeah.
I think that what you'll find what would happen is that you would have, first of all, a regulator who was effectively competing for jurisdiction with the courts. I mean, we've seen this in other areas. Do you see, whether it's to do with the Securities and Futures Commission or other similar regulators, there is a question of who is the primary regulator, and it raises the question of why do you need to have a regulator of trustees at all? I mean, take, for example, a deceased estate. And it might be big, it mightn't be big at all, who knows? The point there is that you immediately run into the difficulty, if you're going to have a law saying that we're going to regulate trustees, you're going to run into all sorts of difficulties. Do you see, if people simply don't qualify as trustees, and yet they are named in a will? And similarly, where you want to reorganize, say, pension funds, and I've got this at the moment, they are already regulated. So all you're going to do is impose another layer of regulation on top, and I can't really see to what good purpose. I mean, just because a person is a public company, it's a trustee, whether it's owned by a bank, it doesn't make any difference, I think, at all. So to me, the whole idea of trying to create a regulatory body for trustees is going to just be slow, expensive, and it ain't going to work.
Thank you.
多謝今日出席嘅。
I'd like to thank the gentlemen for attending our discussion this morning. I'm sure we have had a very useful discussion, and we've clarified many of the concerns of the industry, and the administration has also responded correspondingly. Our legal advisor will later on give us also a written supplement. So I'd like to thank our guests for coming. So thank you very much for coming again. And the 多謝主席係俾機會我哋嚟呢度係發言。With the remaining time, we will come back to the bill. So we'll let our guests leave the chamber first. Originally, we had scheduled to go into the clause-by-clause scrutiny of the bill. We still have about 15 minutes. I'd like to ask the administration whether you want to start the clause-by-clause scrutiny. Certainly, Chairman. Mr. Leung, could we ask members whether there are any remaining points of principle that we need to, discuss first? Because once we've started the clause-by-clause, I mean, we may not have time to discuss those, matters of principle. Yes, thank you. So, are there any points? On principle, I think the industry is very supportive of the bill. My impression is that we may not be able to come up with a perfect bill at one go, and so we've heard those points relating to the principles. So before we go into the clause by clause, are there anything else that members would wish to discuss? Because when we go into the clause by clause, we'll be looking at the details.
項目嘅跟進，即係技術性跟進嘅啫。咁而家我先聽睇有冇。
Let me see whether members have any points on matters of principle. This is an amendment long overdue, and some members also raised the concern about the shortage of resources, and also regarding assets like land. Apparently, according to the deputations, many trusts don't really, include them. But the situation may change in the future. So that's why I believe that there will need to be a review after some time. How much land interest in land is included in trust. I think we can conduct a study that is within the scope of trust. How much of the properties held under the trust are fixed assets of long duration, such as properties which have been locked up under the trust, or whether these properties are left vacant. If they're being used, it's fine. If you have a large number of such property units which are, kept vacant and held under a trust, perhaps the administration can conduct a study. Chairman, now that you've raised this issue, could the industry or the administration give us some information or figures? That is, how much of such, fixed assets are locked up under trust? Well, the trust amendment bill is good for the industry, it's good for our economy, but the only consideration is whether or not it will result in our land resources becoming more and more short in supply. As a result, property prices will escalate further, and this is what we are concerned about. With such information available, we'll be able to better understand how we can, scrutinize this bill. In respect of this concern, could the administration, do something more and give us some information so that we can allay the concerns in the community? Chairman, the representatives of the industry have already told us that what the situation is like according to the experience. According to the administration, what sort of properties or assets held under trust? These will not need to be registered, so we don't have such information. In the final analysis, when a trust is being set up and what assets would need to be dealt with, I think I don't think there's any figures available, but I think that the industry has already told us just now. Despite the scenario that they've described to us, the question is, after we've changed the rule of the game and if it becomes perpetual, will people's behavior change? That would be a matter of judgment. I suggest that we can. I think, as in last time, they gave. I think a certain institute sent in a very detailed submission. So through the Secretariat, we can, ask whether that institute can provide some information for us. Perhaps they've conducted the wrong studies, or they have collected some data, which can tell us the percentage of the properties held under trust are properties. So, well, this is an amendment of the trust law after a long period of time, so perhaps we can, do some work in this regard, and our secretary can liaise with the relevant organizations. Chairman, I agree. It's not that I want to predict how the market will react, and I don't think I can make that prediction. I just want some information regarding what the current situation is. I would like to have more information, if possible. It will also, I think Mr. Aham told us that only a small portion of the properties held under trust are properties. So perhaps we can ask the industry to, give us some information so that we understand.
你有意見？
主席，
Martin. Of course, I've heard the views of the industry, but these are the views of the professionals. But trust does not involve the interests of the industry. But it would be difficult for us to listen to the views of those who want to set up a trust because they don't belong to an industry. So I'm worried that what we've heard may not represent the whole picture. Well, I'm the director of a trust company. I don't think that. I think that for the trustees, the client information is very confidential and sensitive. So there may not be much exchange of information. Well, the Institute only might be able to obtain some data by way of research, but it's not easy to really obtain accurate information regarding the assets held under the trust. Chairman, I'm not talking about that. Even I myself, when I'm a trust, I can ask my auntie to be the trustee, or things like that. I mean, there's no industry to represent people like that. Mr. Abraham Shek. I'm sorry. I like the administration to give us a paper which responds to the submission from the Bar Association. Nobody from the Bar Association is present today. They say that they've already provided sufficient information. How does the administration respond to the submission from the BA? Will the administration adhere to or accept the proposals from the BA? Thank you. Some of the issues raised by the Bar Associations in the Bar Association submission have been discussed before. As to our response to the submission from the Bar. No, I'm not saying that you should give me a response now. I would like you to give us a paper regarding your response to the Bar Association submission. I want a paper from the administration explaining how you respond to the proposals by the Bar Association. It will be. We're not asking you to give us an immediate response. We want, a written response from you to the submission from the Bar. Chairman, in the Bar's submission, they refer to exemption clauses. For example, the point about gross negligence. And they would want a definition for that. I'd like to know how the administration will respond to this request. Secondly, I hope the administration or legal advisor could give us some information. That is, for these exemption clauses, they are governed by other ordinances as well. For example, the Control Exemption of Ordinance. I don't know, there appears to be such an exception, or Unfair Contract Act. They might all have a bearing here. Could the administration give us a paper explaining which other ordinances will affect the validity of such exemptions, whether we're going to amend or not amend, and how they relate to all those other ordinances. This is crucial, I think. I think the exemption clauses, I'm very concerned about the exemption clauses in respect of the validity and so on. See you? Chairman, I think we had a brief discussion on that before. Mr. Ho referred to certain legislation which may apply to contracts, but for trustees, if it's not in the form of a contract, such regulations do not apply to trustees. The exemption clause in a trust deed, the control is only the control under the common law. That is, even in the case of fraud, the trustee could be exempted from the liabilities. But what applies to contracts may not apply to trust documents. Chairman, the deed itself may contain certain contracts. In the trust deed, you may refer to the relationship between the parties, the conditions of appointment for the trustees, how the trustees will be remunerated, and then you would also explain what are the liabilities of the trustees, and the two parties will need to sign So for the person who is up with trust, he will need to put his signature on the trust deed before it's effective. The administration said that this is a deed, it's not a contract. I would have some reservation here. Well, if that's the case, I would like to include all the controls under those ordinances into the trust ordinance. I will not be satisfied by simply adding the provision regarding gross negligence. I would also include the provision regarding unreasonableness and so on. I don't know whether our legal advisor would like to perhaps can also think about this and give us your advice later on.
係就因為時間都差唔多噶啦，所以咧就嗱趕快少少提埋你哋嘅意見咧，俾下一次之前就做啲準備。係阿 Martin 先，再到阿 Ken。
主席啊，我完全同意係合約咧係唔適用。點解我話合約係唔適用咧？就係可以作為一個參考資料。因為合約嚟講，你係兩個人大家去一個係公平嘅一個情況之下咧，係達成一個合約條款，所以佢免責條款咧都有免責條款，但係就比較上低層次啲。但係如果你係一個信託嘅環境之下咧，係有一個我哋叫做 fiduciary relationship， 一個係絕對信任嘅一個關係嚟嘅。咁呢個免責條款嚟講咧，即係嗰個信託人，即係管理信託嗰個人咧，係嗰個責任啊，係比一個普通一個立約者咧係更加為高嘅。所以變咗咧，就佢個免責條款嗰度咧係應該係要比呢個 contract 嗰度咧係更加，即係一個普通嘅合約嘅情況咧係更加要高一層。
OK， 阿 Ken 你
係主席啊，其實我都想即係法律顧問或者係政府俾翻多少少關於呢一個合約同埋一個 deed。究竟即係 control exemption clause 啊等等係咪會 apply 呢樣嘢？嗱，其實阿 Martin 都提過係啦，即係喺個 trust 入邊嚟講咧，嗰個信託人嗰個 duty 係一個 fiduciary duty 應該係高啲嘅。咁但係咪所有嘅即係關於合約嘅所有嘅條例都唔用到喺個信託入邊咧？我又直覺上覺得未必係呢件事，因為其實一個 deed 一個契約其實。
This may not necessarily be true because a deed is a special form of contract. Now, for anyone who has studied law in the university will know. So I'd like to know why is it that the exemption clause doesn't apply here. Perhaps our legal advisor or the administration can give us a more detailed paper focusing on this particular point. Thank you. So our legal advisor and the administration have heard the request of Mr. Leung, and I hope we can have a paper on this particular point? Is it possible? There are too many uncertainties. Well, for exemption in trust, we said that it will not apply only in the case of fraud under the common law. So we say that on this there is a difference, but we'll go back and prepare a paper. And would the administration give us a paper in response to comments by the Bar Society, Bar Association? Yes, a response to the Bar's submission. All right? Can we have a paper on this? Thank you. It will be, because it's about time we end. Date of next meeting is the 4th of June, Tuesday, at 4:30 to 6:30. We hope to have all the relevant papers before the meeting. And if there are no special comments on the information papers, we can go to the clauses directly. Mr. Sheikh. Now, if the papers are not available, let's not rush, because I think the Bar's submission is well written. Yes, it's very detailed. The Secretariat can approach members, and if we think that another meeting is needed to discuss the policy aspects before we go to clause by clause, then it's okay. Sorry, I was daydreaming. What was the date of the next meeting you mentioned? The 6th of June from 4:30 to 6:30 p.m. All right, thank you very much. Thank you, administration.